Welcome to our jurisprudence class tonight. So we would like to discuss the historical school of jurisprudence, which is basically an attempt to understand law through the lens of history. So to start with, those who have studied history before, either in your elementary school, the high school, or even the university, you will appreciate that the knowledge of the past, which is the province of history, which is the subject matter of history, is so important because without knowing the past, it will be difficult and sometimes virtually impossible to understand the present. And if you don't understand the present based upon the benefit of your knowledge of the past, you can certainly not make any meaningful projection into the future. And that is why history is really crucial. History is important. And for that matter, when it comes to jurisprudence or legal philosophy, the attempt to understand the nature of law, we cannot leave out perspectives or viewpoints which history may offer in our quest to understand law, in our quest to understand legal institutions. So that is the backdrop for including historical jurisprudence as part of our remit in this particular course. So what is historical jurisprudence then? Historical jurisprudence, as a school of philosophy of law, seeks to examine how law is an outcome of historical and cultural developments. In other words, it is a view of historical jurisprudence that law did not just happen. Law is a product, an outcome of various historical events, circumstances, and cultural developments. So historical jurisprudence posits that law is not merely a set of rules imposed from above, but a reflection of societal norms and values that have evolved over time. That is really critical. And I dare say that if you don't even want to go far, let's look at constitutional law. And those of you who are on my YouTube channel, Ghana Law TV, there's a playlist or podcast we call Constitutional Law in Ghana. I think there are about 3 or 4 recorded a video lecture on historical evolution of Ghana's constitution. Now, if you, for example, cast your minds back to whatever you learned in constitutional law with respect to Ghana's constitution, you would have noted that the 1992 constitutional architecture, the structure and then the content of the 1992 constitution is not accidental. It is a calculated tablet informed by what we as a people of Ghana have been through. And of course, you remember the famous dictum of SOA JSC into 4 versus Attorney General, which was also repeated in NPP versus Attorney General, 31st December case, and so many other constitutional jurisprudence, that the Constitution is not an ordinary document which should admit of doctrinal interpretation. But more importantly, the Constitution mirrors the history, the aspiration of the people, and their search for a better society. Now, that dictum into 4 verses Attorney General, which have been repeated in a litany of cases before our Supreme Court, is quite pregnant, it's quite deep, in the sense that it immediately reminds us of the necessity of history in attempt to understand the Constitution. So, for example, we take Ghana's Constitution. I will not take you far. If we look at Article 3 of the Constitution, for example, the defense of the Constitution, the substance of that provision is that where anybody has used an unconstitutional means to overthrow the constitutional order founded upon the 1992 Constitution, every Ghanaian is encouraged to do all that is in that person's power and strength to resist any such attempt in order to restore the 1992 constitutional order. And even if you killed human being in your quest to resist such overthrow, should the Constitution be restored, you will be granted a pardon. You will be absolved from wrongdoing for that. Now, why do we have such a provision? That provision is there because of our checkered political history. The fact that we have encountered numerous military intervention. We have had a lot of occasions where the military, for example, have taken over power. And we do not want that to happen again. And that is why our framers of the Constitution, in their wisdom, provided that if there's any attempt to overthrow the Constitution, we are all encouraged to resist it. Now, not only that, if you take the Constitution, there's also a provision to the effect that Parliament shall have no power to make a law turning Ghana into one-party state. Now, wait a minute. Why do we have such a provision? Such a provision exists because we have had a point in time in Ghanaian political history in which Ghana was actually turned into a one-party state. Ghana was turned into one-party state by the CPP during Kwame Nkrumah's time. And all other political parties were actually proscribed or outlawed. We do not want that to happen in Ghana again. And not only that, if you look at Article 1 and Article 2 of the Constitution, the supremacy of the Constitution and then the enforcement of the Constitution. Now, those provisions did not just occur. If you look at the case of Ray Akoto and 7 others, which you know very well, the Supreme Court at the time found itself helpless, saying that it could not actually hold the president to fundamental rights pronouncement that the president makes on assumption of what? Of office. And if anything at all, it was to be treated as a political statement, which the people of Ghana could hold the president accountable to when it comes to election. But the Supreme Court found itself impotent to be able to do that. Now, we do not want that to happen. And that is why we have actually gone the step further and said that, yes, anybody at all can go to the Supreme Court if the person thinks that something has been done or omitted to be done, which is in contravention of or inconsistent with the letter and spirit of the Constitution, and seek a declaration to that effect. I'm giving these instances just to let you appreciate the necessity of history in trying to comprehend the present so as to be in a position to make sense of the future yet to unfold. So then, what is the focus of historical jurisprudence? Historical jurisprudence emphasizes that laws develop organically, influenced by sociocultural and historical context within which society operates. You might have heard of the expression, I think, of course, in various languages, but Akan people will say that Okoto Enwanuma. Okoto Enwanuma, literally translated as a crab does not bring forth a bird as an offspring. Now that maxim or that saying is very much on point in as far as the statement you made concerning jurisprudence, historical jurisprudence is concerned, that law develops organically, influenced by socio-cultural and historical context within which a society operates. So it is the historical reality, experience, the socio-cultural reality, which will detect what law needs to be made, how law should be made, and so on. So let's say that, let me give you a typical example. You've all done land law and also succession. You've done customary law. Now, when it comes to inheritance, when it comes to succession, fundamentally, we have the patrilineal and matrilineal system. The customary law had developed up to the point that, yes, if a person died intestate, your inheritance will devolve according to whether you are matrilineal or patrilineal. So if, for example, you're matrilineal, assuming the man died, the children and the surviving spouse, the wife, will not be given any share in whatever property that the man acquired, unless the man had made insamansew or had made a will, in which case the person will not have died intestate, but the person will have died tested. But if the person died intestate, then we will have to use the proper customary law, in this case, the matrilineal system. I mean, that was certainly exposed in the course of time as we came closer and closer to modernity. I mean, to be very unjust, to be unfair, because how could a man in his lifetime enjoy the support of his children and his wife or surviving spouse, maybe do something, and then when the man is no more, then the children and the spouse are, for example, kicked out of the house? Remember the case of Henry Kofi Antubam. Henry Kofi Antubam, where the court, at another Ray Duje, as he then was, will go to the extent of saying that under customary law, if your father died in a matrilineal society without making a will, then you, the child, you'll be allowed to remain or to stay in the house that he acquired by the family, so long as you have good behavior. I mean, why should your right to stay in your father's house, self-acquired house, be contingent upon good behavior, which will be determined by the extended family members of your father? I mean, that was certainly not right. And that was why in 1985, of course, we have to give credit to the former First Lady, Nana Ajiman Rawlings. Nana Ajiman Rawlings Kunedu, I hope I've not messed up the name. Nana Kunedu Ajiman Rawlings, yes, sorry, thank you. For also her role in encouraging efforts which were being made to also bring about the interstate succession law. So the interstate succession law imposed a uniform regime, regardless of the details of your customary law, that if you don't make a will, then we are going to distribute about 80 or 90% of your estate according to prescribed statutory regime, which was relatively fairer and just than what pertained under the old customary law. Again, historical jurisprudence brings up how historical events, cultural shifts, and societal needs shape the development and interpretation of laws, as I have, for example, demonstrated. And again, if you come to our own constitution, if you come to the 1992 constitution, there is a provision to the effect that even our cultural practices, I think if you look at the Article 18, Article 26. If you look at Article 26 of the Constitution, I quote, Clause 1, every person is entitled to enjoy, practice, profess, maintain, and promote any culture, language, tradition, or religion, subject to the provision of this Constitution. Clause 2, and that is the relevant one for us, all customary practices which dehumanize or are injurious to the physical and mental well-being of a person are prohibited. Now, you notice that in Article 11, Clause 1 and Clause 3, customary law is regarded as part of the laws of Ghana. But then Article 26 says that if customary law, for example, permits certain customary practices which are considered as dehumanizing, that is, lowering our value or dignity as human beings, or are injurious to us as human beings, physically and mental well-being, then such cultural practices are outlawed. So we mentioned trochesy, for example. Trochesy, where Vestal virgins were given to the priestess as an atonement for the sins committed by the family over generation and all that, was consistent with the customary law of a particular group of people somewhere in the Volta region. So there was nothing wrong. But then, in view of human rights provision of the Constitution, that has been what? Outlawed. Female genital circumcision or mutilation, where the clitoris of the female at the vagina is actually removed in order to prevent the woman from being susceptible to all kind of disordered pleasures and so on and so forth. That has been outlawed because it is against this particular provision. So the fact that we have this provision reinforces the claim of historical jurisprudence that it is the cultural, the societal needs which shape development and interpretation of laws. Yes, at some point in time, those things were seen as normal. But now our eyes are open and we've seen that that is not how human beings are supposed to be. So we abandon that. Again, historical jurisprudence will help us to understand legal development as we learn it, because it will provide valuable insight into how and why legal systems have reached their current state, and provide a deeper understanding of the legal principle and their application. For example, we have a jury trial. So we want to find out why, for certain type of offenses, we have a jury trial in Ghana. Now, historical jurisprudence will help us to understand why that is the case. And not only that, so many, for example, we used to have a law, okay? If someone was owing you and the person defaulted and you sue the person to recover the debt, and the court said, okay, yes, you're entitled to get the money. Now, if it happens that the person has been served with all the entry of judgment or notices, and he or she was not forthcoming in coming to pay the money, you could actually have the person summoned to court to come and show cause why he should not be detained or he should not be imprisoned for his or her failure to pay his just debt as determined by the court. Now, that law has been abolished now by interpretation of the Supreme Court that it is against human rights that no person should be incarcerated for failure to pay his debt. But for a long time, it was part of our law. And again, when it comes to the court structure, there was a point, we have a regional tribunal. You want to understand, has Ghana always had a regional tribunal? We look at it and you say, no, the regional tribunal and other tribunals only emerged when the Fourth Republic Constitution came into force. You want to understand, how did the tribunal become part of our court system? As you do the investigation, your mind will go back to the coup d'etat, which was made by Rawlins in 1981, trying to say that he was restoring power to the people, that ordinary people should participate in the administration of justice. So they set up the tribunal system. And later on, when we have to return to constitutional rule, they find a way to retain some of this tribunal system. And that is why in the Constitution, we still have the regional tribunal. So here, it is history which has provided an explanation of that particular institution. And that is why historical jurisprudence is important. So historical jurisprudence is worth learning because it will imbue you with the critical analysis skills, which will help you to explain the how and then the why of current legal practices and statutes, particularly as you begin to know and understand their historical roots. And once you understand their historical roots, you are in a position to question their usefulness to current society, or where they need to be changed or they need to be modified. And again, historical jurisprudence will also help us to appreciate the diversity of legal systems. Why is it that Ghana is a neighbor to Cote d'Ivoire, to Togo, to Benin, Burkina Faso, but all these countries surrounding Ghana, their legal system, and particularly so their legal tradition, are fundamentally different from what pertains in Ghana? The way law is organized, the way justice administration is organized is completely different from those countries, from what pertains in Ghana. Why is this so? You begin to understand that, yes, their legal system belongs to what we call the civil law tradition, or the continental legal tradition, or Roman law tradition, because they were colonized by Napoleon Bonaparte's France. And then, so history now begins to let you understand, then Ghana too, why we belong to the common law tradition, because we were colonized by the British, and they have like the common law tradition. So what are the key ideas as far as historical jurisprudence is concerned? I have already shared the PDF version of Hazen's jurisprudence with you on your platform. So I expect that you read chapter 13. You read chapter 13 of that to complement or supplement the discussion that we are doing. It's a very short chapter. Now, first, it is a claim of historical jurisprudence that law is a cultural norm. That is to say that law is not merely a set of imposed rules, but emerges from the customs, traditions, and values deeply rooted within a society. So that is one important observation one can make as far as historical jurisprudence is concerned. And this has an implication. An implication is that it views law as an organic living expression of the society's moral and ethical standards. And that is why we say that law is an outcome of historical and cultural development. So in Ghana, for example, we have traditional norms regarding land ownership and family relations. And these continue to influence formal legal processes and property law. For example, if you even go to civil procedure, when it comes to parties initiating suits, if you want to sue, if there's a family property and a suit will have to be mounted, the position of the law is that it is the head of family, the Busuapenyi, who is supposed to initiate it, isn't it? Or where the head of family, the Busuapenyi, has failed to act to protect the property of the family, any member can actually initiate an action. But when you initiate the action, the law requires that you have to bring it to the notice of the head of family, so that the head of family will decide whether to come and take over or allow you to continue. So you see how our even civil procedure or civil justice is being influenced by our traditional system of customary law, as it were. In the same vein, when it comes to land law, we have the customary law interests, like allodia, its virtual interest, the tenancies, abunio busan, and all that. They have all become part of our land law, in addition to the receive common law land interests, freehold, the freehold interests, leasehold, tenancies, license. Now, historical jurisprudence also identifies what we call the Volkgeist, the spirit of the people. So there's this particular scholar, Frederica von Savigny. He is the one who noted what is known as the spirit of the people. And what does he mean by the spirit of the people? The spirit of the people, according to Carl von Savigny, is supposed to be an embodiment of the common spirit of, or the collective consciousness of the people. So the collective consciousness of the people is what it means by like the spirit of the people. So, for example, In one of his writing, Savigny will make the point, quote, writing in relation to German code, he would make the point, quote, we first inquire of history, how law has actually developed among nations of the nobler races, that what binds a people into one whole is a common conviction of the people, the kindled consciousness of an inward necessity, excluding all notion of an accidental and arbitrary origin. And he will make the point that all law is originally formed in the manner in which, in ordinary but not quite correct language, customary law is said to have been formed. That is, it is first developed by custom and popular faith, next by jurisprudence, therefore by internal silently operating powers, not by the arbitrary will of a lawgiver. So that is saying that it is that common consciousness which drives development of the law, and not just arbitrary will of a lawgiver. It's not just someone just sitting down and say that, okay, let me introduce this law or that law. No, he is rather saying that there are certain forces operating within society silently, and those silently operating forces are what he means by the common consciousness, which actually drive the development of law. So the custom of people embody its common consciousness, and from them, law grows in an organic, unconscious fashion. So law must resonate with the inner convictions and daily realities of the people, grow and evolve with them over time. And if you look at customary law, that is how customary law actually grows. I will use, let's say, of course, this is the Presbyterian University we are dealing with. So you are in Kumasi. So we use the Kumasi, the Asante, customary law and Asante people as an example. You notice that the Asante Hene, or the king of the Asantes, is highly regarded by all through Asantes. And where certain practices or usages, for example, have been there relating to, let's say, our chiefs and so on, regardless of how people are educated, or regardless of even the religion which people subscribe to, you notice that by and large, they still show respect to those practices, because there's that inner convictions that is us, or that is how they are. The third point to note is that historical jurisprudence is antithesis to codification. In other words, it is against codification. Codification, by codification, you have encountered it in your criminal law. You have the criminal offenses code, criminal procedure code. In company law, we used to call it companies code until it was changed to an act. So when we talk about the codification, we are talking about a systematic collection in comprehensive statutory form of the laws of a state. So when the laws of a state have been compiled in a logical, systematic order, then we have a code. So that is what codification is about. And we are saying that historical jurisprudence is actually against codification or against adoption of codes. What does code achieve? Codification or codes seeks to get the law standardized and codified. You take Napoleonic Code, for example, where all the laws on major thematic areas are compiled together to ensure that necessary adjustments are made to achieve internal coherence, logic, and all that. Now, what is the argument against codification by historical jurisprudence? It is the claim or the thesis of historical jurisprudence that codified laws, that is when laws are put in a code, they can become rigid and may fail to reflect the current values and needs of the people. And that can potentially stifle legal evolution. Because once you have a code, the thing about code is that a code is like a self-contained statement of the law. The various interpretations are also included. So you draw upon the four corners of that document, the code, to try and decipher the meaning, uncover the meaning, and also apply it to practical situations. So there's no room for any external material to be drawn upon, as it were. So imagine the code has been made about 50 years ago, 100 years ago. That may be out of step with how society has evolved. Society is not static. Society is dynamic. And because society is dynamic, the way we view things keep evolving, keep shaping, changing, as it were. And even in our own times, we can even appreciate some of these rapid changes. So we have the challenge of striking a balance between the benefits of a unified legal code. Of course, if you have a unified legal code, it also brings certainty. Everybody knows what the legal position is likely to be. So there's that advantage of enhancing certainty. But there's also the other side, the need for the law to remain relevant and reflective of societal changes. So how do you seek to navigate the balance? Yes, having codification and for that matter code will enable you to have certainty and stability in the law. On the other hand, it may also be counterproductive as it becomes impervious to changes which are occurring in society. So what you may end up having at some point is that what people are doing, in fact, are different from what is contained in the law. So that is the challenge. So you take like the companies code. Why we abandon the companies code and then we embrace Companies Act? I think if you remember your company law, there's a provision, a number of provisions, which actually made the idea of calling it a code a flawed concept. So those who made the law in 1963 Act 170, which is repealed, I think they actually more or less made a fundamental error in choosing to call it a code. Why is it so? There were provisions in that law, for example, which makes the point that where the express provisions of the company's code then were not inconsistent with the common law, then the common law on relevant matters was still deemed to be part of the law. Now that is not the idea of a code. We know the common law itself is not codified. The common law is scattered through various judicial decisions. So if you have a legislation in which it says that unless the contrary is indicated, otherwise the common law is still deemed part of that particular, then you haven't codified, because you still have to work your way through a lot of case law or decisional law before you be able to ascertain the true position of the law at every point in time. For example, when it comes to duties of directors, that statement was there, that the common law relating to duties of fiduciaries and all that were applicable to the duties of directors, so long as there were no explicit contrary provisions in that legislation. And that is why, happily, they abandoned the labor code and adopted an act. So we have like Companies Act. Now, can you think of a law in Ghana that has changed due to shift in societal values, apart from the ones that I have mentioned in this lecture? Can anybody think of an example? I want one female and one male before we continue. Raise up your hand and I will release your mic for you. Yes, Taminu. Yeah, Taminu, go ahead.
My Lord, there's somewhere last year, I think either 2022 or last year, attempted suicide used to be a crime in Ghana, but it has now been decriminalized. And then the Chief Justice, through the Judicial Secretary, wrote a letter to the various lower courts about the change in that law. So I think it has changed as a result of our focus now on offering support to people with mental health issues instead of seeing it as a crime as it used to be.
Right. Thank you, Taminu. Taminu, if I was a rich man, I'll give you a gift of $100. I know I'm not rich, so you don't get it. Thank you. I think the female too, or is there? Yes. Which female is okay? Let me see. KA. Okay, it's a female. KA. Okay, let's hear you. Okay. I think he is not ready. Okay.
My Lord, please can you hear me?
Yes.
Okay, thank you. I'm a broker. Yeah, one law that comes to mind regarding this one is the marital rape. You know, prior to 2007, marital rape was not recognized as a crime, you know, in Ghana. However, with the shift in societal values and recognition of women's rights, there was this Domestic Violence Act in 2007. I've forgotten the exact act, but after it was passed, it has now recognized marital rape as a crime. So that is what I'm thinking.
Right, but are you aware of any case in which there has been a successful
Does this change reflect
right.
I'm not aware officially, except
Okay.
unofficially. So once it is unofficial, I can speak to it.
All right, good. Yeah, so there's a Carl von Savigny that we have mentioned is one of the founding proponents of historical jurisprudence. He's from Germany, and he, as we have said, proposed the idea of Volkgeist. The law originates organically within the culture and tradition of the people, as it reflects the spirit and collective consciousness. So he made the important statement that law grows with the growth and strengthens with the strength of the people, and finally dies away as a nation loses its nationality, unquote. So he saw an important nexus, important connection between national identity, national consciousness, and the law, so that as the people continue to hold on to their nationality as a people, then the law will be strengthened. But then as the people lost their nationality, the law will also be weakened and eventually even die, as it were. And as we have, so he was against the adoption or imposition of code, universal legal code like the Napoleonic Code, and he rather wanted a natural development of the law from within the community. And that is why he talked about the silently operating of forces. And Savigny's approach has actually influenced how scholars view interpretation of laws. And when it comes to interpretation of law, historical context and cultural specificity, for example, are important. And I think it's referable to some of these ideas which Savigny actually propounded. Even if when it comes to interpretation, in your legal method, remember how they call it the mischief rule. The mischief rule or the Hayden's rule of interpretation. And now in modern times, you also understand the purposive approach. If you look at the purposive approach and even the mischief rule, all of them have got some relevance to what we are talking about. Because we need to understand what was the problem. What was the problem which the lawmaker sought to cure? Or what was the mischief which the lawmaker sought to cure? What was the purpose of the lawmaker in making this particular law? So the purpose or the mischief which was sought to be cured will play an important role in shaping how the court uncovers or interprets the meaning of the particular law. We also have another proponent, Sir Harry Maine. He is a British, and he also made important contribution to this particular school. What did May bring to the table, which let him stand different from what von Savigny had actually told us? Well, Maine proposed that societies evolve from status-based. So look at the expression, status-based to contract-based system. So Maine made a very important observation that, in his view, if you study various societies, you notice that society has moved from the operating on basis of status of people, status like standing, status, to rather a contract base. Like if you look at the British society, for example, it was a society which was really stratified, various classes, the lords, the peers, the commoners, and so on and so forth, the aristocrats. So that was status. So how you transacted in the society, how you move about, and how you did things was very much dependent upon status. Were you a free man? Were you a slave? Were you this or that? Now, Maine was of the view that society had actually transitioned from that to a new paradigm, a new orientation, which is contract, that it is now contractual arrangements which determines relations that exist between people. So there's been a shift in the legal and social structure. So that's the point that Savigny makes. So unlike, that's the point that Henry Maine makes. So unlike Savigny, who focused more on the organic and cultural rules of law, Henry Maine emphasized a more structured progression of legal system from primitive to more complex forms. So it is to Maine that we owe the idea that society has moved from status to contract. And he will make the famous statement that the movement of the progressive society has hitherto been a movement from status to contract. Now, if you wanted to see relevance of this view of Maine, you may probably look at the field of the labor law or employment law. If you look at the employment law, if you look at the common law, if you look at the common law, for example, you look at like the common law, for example, you notice that for a long time, the relationship between the worker and the employer was viewed from the relationship between master and servant, master-servant relationship. And the employee or the worker has relatively no right, as it were. But of course, thanks to the International Labour Organization, various conventions, and also thanks to the paper documents, some writings by the Pope many years ago, which have all worked together to improve the lot of workers. So now we have elaborate, even in Ghana, we have like the Labour Act, which has actually, guaranteed various rights for workers. So now the relationship is now more contractual rather than just a status. Yeah, so in terms of like the core principles, if we take Savigny, he talks about the spirit of the people, which you have explained, and he rejected the codification. We have explained that we not believe at the point. Now, Maine, he also talked about the progression of legal system from status to contract. So he holds a view that legal system evolved from being based on fixed social statuses of individuals to system where relations are governed by contracts. And this reflects greater individual autonomy and flexibility. And of course, that is the case. When it comes to an employment relationship, the employee can serve a notice or lose 1 month pay in lieu of. An employer can also do the same thing. And of course, by the movement from status-based system, you're talking about things like the feudalism. If you remember the feudal system, where we have a laws, the land laws, and people who were under them on their land were supposed to provide military services if the need arose. And their use and enjoyment of the land was very much dependent upon the relationship they have with the Lord under the feudalism. But now we have a contract-based system, which also explains the modern legal frameworks that we have. Now, Sir Henry Maine makes the point that there have been 3 stages of legal development. The first stage, personal judgments. So he makes the point that early legal systems were characterized by rulings based on the personal judgments of rulers or patriarchs, and who were believed to be divinely inspired. So that was the initial stage of legal development. Then that gave way to second stage, customary law. And here, it meant that as society became more and more developed, law became more standardized through customs that were informally agreed upon and practiced within communities. And then the third stage, courts. So Maine sees the final stage in evolution of a legal system as adoption of code, where laws are formally codified so that they provide a clear, structured, and universally applicable set of rules. So when the society has reached this stage, then the society, according to Sir Maine, will have gone like the full cycle as far as law is concerned. Well, Sir Henry Maine was very critical of natural law theory, and he posited that, of course, we know a natural law theory from last semester, which was the view that we have a universal set of laws applicable to all human beings based on common rationality and morality. So that is a natural law claim, as we saw. But Maine thinks differently. And in his view, the insistence on universal law by natural law is problematic because it ignores the unique historical and cultural context of different societies. And for that matter, it cannot effectively govern the diverse realities of human existence. Of course, there seems to be validation of his viewpoint if you look at the 24th Attorney General dictum that I cited at the beginning of the class, that the Constitution and for that matter law mirrors the history and then aspiration of the people. If that is so, various societies have their own culturally conditioned historical circumstances. The history of the people of Ghana is not necessarily the same as the history of the people of Nigeria, or the history of the people of Burkina Faso, or the United States, or Great Britain, or Russia. And for that matter, it would be wrong to suppose that there are a uniform set of principles which are equally valid in all these societies. According to Maine, such an approach by natural law certainly ignores the diversity of historical circumstances of the societies involved. So, as we have said, Maine's theoretical framework is that the movement of the progressive society has either been a movement from status to contract. So in examination, for example, This statement could be put there and attributed to Maine, and then you are invited to critically comment on this. I've already given you examples from a labor law. And also when it comes to family law too, you can probably see examples. Now, to a large extent, even marriage is being seen more and more and more as a contractual. Because we did a legal positive and natural law last semester, I will not belabor the point. Good. So I think that we have considered like the substance of the historical jurisprudence. So maybe let's say a few words about the criticism or the downside of historical jurisprudence, and then we'll be in a position to draw down the curtain on tonight's class. Yeah, so no theory of law is sacrosanct or is immune from criticism or downsides. The same thing applies to historical jurisprudence. So what are some of the criticism leveled against historical jurisprudence? First, there's this criticism of selectivity in historical interpretation. And by this, critics argue that Savigny and Sir Henry Maine selectively interpreted historical data to fit their theories, and that potentially overlooks contradictory evidence. That is to say that what these scholars sought to do was just to pick and choose from historical data what they wanted to use, and they used that to make their generalization and extrapolations. And for that matter, there's a big problem, because the other available data that they could have used could have provided some contradiction to the portion that they chose, on basis of which they made their general claims and then extrapolations. So the implication here is that the selectivity they did could lead to biased legal principles that do not accurately reflect the diversity of historical experiences in societal developments. The other challenge has to do with the relevance of a custom. How do these scholars account for relevance of custom? Yes, the problem has to be this, that custom can become outdated and may not effectively address modern societal needs, particularly in rapidly changing societies. And we can see the same thing in our own country. If we had the time now, I'm to allow you to bring examples. You have a lot to tell us. So we have customs that restrict rights based on gender or ethnicity. And this may conflict with contemporary values of equality and what? And justice. For example, Amanda Kans, we used to say that Obato etua etrebe madem, which effectively meant that the woman was not supposed to be economically empowered, so to speak, and it is a man. But that is really not the case, according to modern thinking. Modern critics also focus on the practical application of historical jurisprudence in today's globalized and diverse societies. So here, they point out that historical jurisprudence may struggle to adapt to new social realities or technological advancements. Particularly if you look at the internet, the digital world. artificial intelligence, how things are evolving very fast. So how do you use the claims of historical jurisprudence, either Savigny's Volkgeist, the people's consciousness, or the three-stage development of Maine? How do you use that to explain some of these rapid changes? There's also the tension between the need for laws that accommodate global standards and those that reflect local customs. So these are some of the criticisms which are leveled against historical jurisprudence. So the question I ask is that, is historical jurisprudence still relevant in the era of international law and human rights? I would like, I'm giving this to group 1. So group 1, you have group 1 and group 2. Group 1, you have to take the position that historical jurisprudence is still relevant in the era of international law and human rights. So you are speaking for. And then group 2, you have to take position that it is not. So you are against. So I'd like you to prepare your presentation and then upload it on the class platform latest by Friday, so that we will add it to our other outstanding presentations. And now to the whole class, your assignment, individual assignment, with reference to historical jurisprudence, critique the usufructuary interest, which is still part of our land law. So this is your assignment, and you are supposed to get it ready by Friday. I'll put email address or on the platform, and you have to email your answer to that. So that will mark the end of our discussion tonight.